general discretion, which your lordship is constantly finding out on case-to-case basis, will create chaos. Lordship is saying
he has no option according to you. According to you, even if the bill is apparently impinging upon these provisions.
But he is not the judge. I am agreeing with my lord is right.
That after the subsequent articles are taken into consideration.
Look at it after that.
This could be revisited.
Revisited, exactly. Revisited is the right word. Revisited is the right word. Revisited, and those articles may be having specific provisions saying you have a specific discretion. Then therefore you will fit in then. If you have a specific provision, we have no problem. But this whole argument of general discretion, which your lordship is constantly finding out on case-to-case basis, will create chaos. Then Dr. Ambedkar broadly supports Mr. Krishnamachari and says the same thing, other such articles which specifically reserve. That's what he says. Some of them are coming later, some are there. He says other have exact provision. Empowering, enabling, using diverse words, all are quoted there. They are quoted there. So I have done now, with my proposition, which said that even on a general issue of discretion, no such general discretion was envisaged. This is on the entire concept of discretion of a governor. All the relevant things according to me have been covered. And the thrust, your lordships can have a sentence word here, thrust is clearly that you are not there without specifically conferred discretion. Now I come to two sets of argument, the first of which is only showing material which I believe has strong resonance to suggest that for each of the three options, first one doesn't matter, but the first one anyway, he gives assent. Second and third option, he still acts on the binding aid and advice. Second and third. And immediately after that, I'll come that very well, I don't press the first one. In any case, he at the most will have one referral back and one presidential reference. So I'm dealing with this in separate boxes. Page 29 is my first set of submissions that your lordship will see some paras which may throw light on this because your lordship will get a complete picture. If I'm partially right or right in this one, then I'm certainly right on the next point. Therefore, just see this passage which suggests that they intended not to have any discretion with the one exception of second proviso.
The second option of withhold not arise unless it is a private bill. Because the bill would be present in his house only on after the cabinet approves it. So there would be no question of withholding it.
No, I've dealt with it. Let me oralize 30 seconds. Now we are considering the argument that all the three options he has to act on the binding aid and advice. My Lord the Chief rightly asked me, why have a second one of sending back on the binding aid and advice of the council? Right? Well, that's one. The answer is there are many situations where the government wants a rethink, a change of policy. We have noticed some error. We want to make an amendment. We want to make a mid-course correction, or we want to call it back and rethink the whole issue at all. We will not send it back to you. All these are possibilities why you will act even on the second option of sending it back. I'll develop it in a minute.
Okay.
The third option of the presidential arises where the government frequently either knows that this requires presidential assent. There are provisions I am showing where the provision requires presidential assent, the constitutional provision requires presidential, or the government is in doubt that there is some competence issue where it is better that the governor send it to the president.
But suppose if the governor himself has doubt.
Therefore, that is my next argument. In this argument, I believe he cannot have a doubt. He's bound. He's bound.
If he has a doubt that the statute is repugnant to some central statute.
So, in my first argument, which is only based on
whether the governor will not have a discretion.
I appreciate. Therefore, I have divided it. The next set of arguments is that he has the discretion, once to send it back and once to the president. That's the next set of arguments after page 44.
So that is your alternative argument.
Alternative argument.
That he has a limited discretion.
For me, it makes no difference. Please accept that. But there are 5 pieces of evidence, 2 judgments and 3 speeches, which suggest that my prior argument is not without solid material. That is bound by all 3.
Yes. For example, something impinges upon 286, 287. Then in which case, what would happen?
In which case,
suppose the bill impinges upon issues connected to 286, 287,
yes,
or 288. or certain other, I'm not mentioning all the provisions. And if it comes to him, and definitely the council will not advise it to be referred back, or would always be insisting for an assent.
Yes.
What would he do at that time?
No,
State will anyway not ask for a
yes.
reference to the president.
No, I'm not saying they will ask on this case. I'm saying, Malas, what your lordship is saying,
He is no option according to you. According to you,
He
even
has
if
no
the
option.
bill is apparently impinging upon these
absolutely.
provisions.
But he is not the judge. I am agreeing with, my lord is right. The governor is
Glaring-
not the judge
take a
of
glaring
illegality.
example. Take a glaring example. No, we are just asking you, just to test the proposal.
I don't want to take a glaring example of the kind listed there, which I'll be showing in a minute.
No,
Those
not
are-
on that basis.
Now,
We are saying if it is apparent
yes.
from the bill that it is impinging upon those specified in the constitution itself, but there is a difference of opinion between the council of ministers and the governor, and governor thinks that it is apparently directly impinges upon,
Yeah.
you are saying that there is no such option for him
So
except to,
what is my answer? The answer in the second set of submission, which I'm now on from page 29 to 44, is no option.
that's it.
That is no option. This bill may be illegal. My lord is right. After he appends his signature, it will be challenged in court. Your lordship may want to strike it
We
down.
wanted to know.
The constitutional scheme will not change about the binding nature of the aided advice. Barring Malas, I don't again repeat want to go to examples that he passes a bill that I take over the Taj Mahal. He passes a bill that the government of India should be
You go
dissolved.
your own way.
So that is not.
But if that approach
Yes.
you take, then the second question becomes even more important.
Yes.
When you say that once it comes back, he has no option. At least at that stage, there is a possibility for him to refer to the president, saying that I've told you that it is impinging. He could have.
That is coming later.
Just
I'll
examine
keep in
that.
mind this.
That is his third argument.
Examine that.
That's the argument after that.
If you consider,
That's the argument after that.
The
Because
third option.
I am not
you're just flagging it, that's all.
I am glad. I'm very glad.
He said in the beginning itself that there are three alternative arguments.
So, Malas, my lord is right, absolutely. That I'm not conceding at all. I'm saying the entire structure I'll read of 200 and the first proviso is the initial stage structure. It's the initial stage structure. In fact, Malas, he then can take chances. The referral back can become a device to refer to the president, which he never thought necessary to refer to the president. Anyway, let me come to that. That will be in its place. Let me first make the first argument only because there are, according to me, some resonance in these five pieces which suggests that in this work he is bound. His job is not to, in practice, the example my Lord Narasimha gave, it is entirely possible in a normal harmonious thing which we have seen many times. We have known many governors and chief ministers. They'll pick up the phone and say, look, this is not quite right. That is 286. That tradition may be vanishing fast. We don't know. That tradition may be vanishing fast. But, brothers, those are practical solutions to real problems, much lasting nature. But if push comes to shove and your lordship is asking a constitutional question, then this proposition is that he's bound. And it will be set aside by a court of law. So the organ created is your lordships. That's not the organ created. Now, brothers, kindly come to